You're watching TechShark, bite-sized news for conservatives surfing the net. Unlike other shows, we're not just complaining about big tech tyranny or media bias. We're talking about how the conservative movement is starting its own solutions and changing its game plan to take on big tech. Former President Donald Trump announced a few days ago that he would file lawsuits against Facebook, Google, and Twitter, as well as their top executives Mark Zuckerberg, Sundar Pichai, and Jack Dorsey at a July 7 press conference. Will it be the legal case to break the tyranny of big tech censorship? Well, today I have the honor of being joined by Parler Interim CEO and Convention of States President Mark Meckler to help us figure that out. Thanks for joining us on TechShark. Can you tell us a little bit about the Convention of States and your big plan for America going forward?
Sure, absolutely. So Convention of States utilizes the second clause of Article 5 of the United States Constitution, which gives us, the people, acting through the states, the right to call a Convention of States to propose amendments to the Constitution that would specifically restrain federal tyranny. So that's what we're doing. It takes 34 states to call the convention. So far, 5 million people are involved all over the country. We've passed the resolution in 15 out of the necessary 34 states. Just in the last few weeks, we passed the North Carolina House, the South Carolina House, the Wisconsin Assembly. Tens of thousands of people are joining at conventionofstates.com. We're absolutely going to take the power away from DC and give it back to the people.
That sounds incredible. So can you describe the unique legal theory that Trump's attorneys are deploying in their case against big tech with these lawsuits?
Yeah, this really is unique. So what they're claiming is that it's a First Amendment violation for him to have been censored and then ultimately kicked off of these platforms. What makes that so unique is when we say that there's a First Amendment violation, what we're usually talking about is the First Amendment is a way to restrict what the federal government does. It actually says that Congress may make no laws infringing freedom of speech. And so we're normally dealing with Congress passing a law to infringe freedom of speech. In this case, obviously, you're talking about private entities that are infringing freedom of speech. And the question is that in some way unconstitutional? Traditionally, we would say, no, it's not, because these are not state actors. President Trump's legal theory and what his lawyers are claiming is that these companies have somehow been converted to what we would call a state actor by either their actions, the way government cooperates with them, or their control over the marketplace generally. It is a new theory. It is a theory that's been talked about for quite a while among academics. The courts generally don't rule that this is state action, but I think there are some unique things here where the courts could go that way.
Absolutely. I remember Trump specifically mentioned that, quote,
while the social media companies are officially private entities, in recent years, they have ceased to be private with the enactment and their historical use of Section 230, which profoundly protects them from liability. Once they got Section 230, they're not private companies anymore in a lot of views.
As Trump noted, those on the left and even some on the right have argued that big tech companies are private companies and that free speech protections do not apply. Can you go into why big tech reliance on Section 230 in particular just might be the Achilles heel that gives conservatives a strong legal case?
Yeah, Section 230 arose out of the Communications Decency Act. I think it was 1996 when that was enacted. And the intent was to protect these companies when they censored content. And what we were trying to do, this is a very conservative thing, they were trying to prevent these companies from having to allow pornography on their platforms. There's a distinction between a platform and a publisher. Publishers do censor content. You know, if you have a podcast or a show like yours, you can decide exactly what you want on or not want on, but you're going to have responsibility for everything that's on because you control the content on your platform. So these companies said, look, we're not going to control the content, but we do want to make sure that we don't have to post pornography, for example, on Facebook or Twitter. And so this exemption was given to them from liability for that kind of moderation, that kind of content control. Unfortunately, over the decades, what's happened is they've turned the idea of content control far beyond pornography and things that are genuinely offensive. And they've used part of Section 230 where it says, or things otherwise objectionable, to say that everything people like you or people like I would say is objectionable. It's ideological, it's political, it's theoretical, it's just stuff that the left doesn't like. And so Section 230 has now been used as a weapon against conservatives. That's where the problem is, and that's what they're trying to address.
Absolutely. You know, one of the major themes of our time is that we see liberals play all these semantic sort of shell games to gaslight conservatives, suggesting their concerns aren't valid. They say stuff like, Antifa, well, that's just an idea, critical race theory isn't real, or it's not taught in schools, or as Axios said just this week, quote, to date, Trump and other conservative critics have not presented any substantial evidence that either platform is biased against conservatives in its policies or implementation of them, end quote. So what would it take legally to convince a court of law that conservative censorship has taken place and that such cases are actionable?
So the real question here is in the final words, you said that the cases are actionable. I think the facts are clear. I think facts can be demonstrated numerically in specific instances that there is definitely a bias against conservatives, against right-wing ideology versus left-wing ideology. The question is how or is that actionable? So this question revolves around whether these companies can be deemed to be state actors. There's a few different ways to reach that possibility. One is saying that Section 230 makes them a state actor. It's a stretch. All of these, I'm going to be honest with you, are stretches. It would be an expansion of First Amendment protection that the courts have yet to be willing to accept. One is Section 230. Two is the idea that they're just so big that they are essentially acting as a government, in fact. In other words, they control so much of our speech that they control the public marketplace for ideas, and they have to be restricted the way we restrict the government. I think that's the longest shot. Another way is by saying that the government is actually working in conjunction with these companies to cause censorship. In other words, the government would not be allowed to do this kind of censorship. That would clearly be unconstitutional, but they're getting other people to do their bidding to do things that would be unconstitutional for government to do. So it should be deemed state action. And then the last one that's really interesting is that they're actually coercing these companies into doing things that would be unconstitutional for the government to do. We see evidence of that when you see these committee hearings run by Democrats where they call they call Dorsey before, they call Facebook before, Zuckerberg before, all of these folks before Congress and threaten them that we are going to regulate you if you don't stop or censor the misinformation. So that's a threat, getting them to do something that would be unconstitutional if the government were to do it. Again, you could imply that that makes them a state actor or an extension of the government, and the First Amendment would apply.
Absolutely. One particularly grim irony I've noticed is that when big tech platforms create rules with a leftist slant and then censor conservatives based upon those rules, then big tech companies can claim that conservatives aren't censored for their views, but were instead censored for breaking the leftist rules that big tech itself created. It's so slippery and hypocritical. What legal avenues should conservatives pursue to protect their speech online?
Okay, so we have Trump's lawsuit, and I think that's a good start. Again, I'm going to say it's a stretch. Most likely it's going to be dismissed. It probably doesn't fulfill a First Amendment claim. I would say next is really state attorney generals should be going after these companies for antitrust violations and also for consumer protection violations. Most people, when they sign up, when they open a Facebook account, I mean, they absolutely accept the terms and conditions. But I can tell you as a lawyer that's been involved in this field since '93, we know darn well that people don't read the terms and conditions. They check the box. The truth is, and there's statistical studies on this, the longer, more complex and impossible to understand that lawyers make the terms and conditions, the less likely are that people read them. So this is actually an intentional fraud on the American people. They don't know what we do with their data. They don't understand that the presentations will be biased or that will attempt to manipulate us while stealing our data. And so I think consumer fraud, consumer protection is a good way to go. We now have 37 attorneys general taking action against Google right now on data issues. There are different attorneys general all over the country looking at the consumer protection aspects, at the trade protection aspects, and at antitrust aspects. So I think this is really the strongest way. We should be litigating against these companies in any way we possibly can. The more, the better.
Absolutely. You know, Trump seems to acknowledge that conservatives need to be represented not just on alternative platforms, but also on big tech platforms that have acted and continue to act as a public square for national conversations. What are your thoughts on that whole divide?
Well, generally speaking, I would agree. So, for example, my organization, Convention of States, we're active on Twitter. We are active on Facebook, and we'll continue to be as long as we can be, because it gives us access to an audience you can't get elsewhere. The numbers on Facebook, the numbers on Twitter, and the main social media channels, there's no comparison on the secondary channels. At the same time, we ought to be building out our own networks. I served, you mentioned this, as interim CEO of Parler. When they got taken off the air, I helped to get them back on the air, and I stepped back once we got them back on the internet. But I think it's important for Parler, for all these different places to step up, to build out the networks and all kinds of layers of technology, by the way, the hosting, the DDoS protection, all of these things are necessary for conservatives to be online. And we're going to have to step up. Donors, business people are going to have to invest the money, or we're going to lose the ability to speak. Free speech is the essence of the fight. Without free speech, without being able to be heard on the internet, then all of the causes we care about, whether it's voting rights, whether it's ballot integrity, whether it's things like right to life or gun rights, we're going to lose all those fights if we don't have a place to speak online.
Absolutely. I hear you on that. We've definitely got our work cut out for us. So we're about out of time, but hey, it's been an honor speaking with you, sir. Thank you so much for joining us.
Thank you for having me. I appreciate the work that you do.
You've been watching TechShark. Once again, I'm Alexander Hall with MRC-TV and Free Speech America. Have a good week.